Dr. Boxer did actually steal some of my stuff, but he was talking about the future of healthcare, and I unfortunately need to talk about the present of healthcare. So while Dr. Boxer envisions a utopian world where a doctor licensed in one state can practice countrywide, we're not there yet. And in fact, he was right about one thing, and that is, he was right probably about several things, but one thing I'm going to mention right now is, let's see, that the technology is outrunning the legal framework. We have in this country 50 states that each regulates medicine within its borders. We have really, excuse me, very little national health care law. What people think of as national health care law, maybe the Stark law, maybe the anti-kickback law, it's all related to Medicare, which of course is an insurance and delivery program in the federal government, but it's not a federal law regulating healthcare. And really, healthcare is regulated right now in the states. As Dr. Boxer said, they have walls up around their states, and that is where we are right now. But again, technology is outrunning the legal framework, so states are rushing to, and the federal government are rushing to keep up. We all know that there has always been multi-state practice in this country, back to the practice management, the public practice management companies of the 90s. But telehealth, obviously, because the technology is there to reach so far, so fast, and so many, accelerates, excuse me, the expansion across state lines. And even though, again, the day may come when this is not the case, channeling Marco Rubio, a practice model legal in one state is not necessarily exportable to another state. So in the old days, if you had a really good idea for a healthcare business, you would set it up in your state. If it involved the practice of medicine, you would have a doctor licensed in that state, and you would consult your lawyer, and your lawyer would tell you how you could legally set it up in that state. And after you became fabulously successful in state number one, you might look to neighboring state to set up your urgent care business or whatever else it was next door. And you would, in that model, either have your lawyer look up the law of the state next door, or you would go to a healthcare lawyer in the state next door. But now, what you're talking about is potentially, with technology, practicing in 50 states, and that means that you are potentially looking at 50 state laws. Okay, so when people think about telehealth laws, the two things that immediately come to mind are licensing and parity. Licensing, Dr. Boxer touched on. Right now, doctors are licensed in individual states. Nearly everyone already knows that the provider needs to be licensed in the state where the patient is in order to have a legal telemedicine encounter. The structuring issues obviously come down to whether you're going to engage doctors in every state, or do you cause doctors to become licensed in multiple states and try and do it that way. In the United States now, not quite 50 state licensure, but in the United States now, there is an interstate medical licensure compact, which doesn't take over or take away from the states their individual control over licensure, but it is an expedited process that improves portability and improves, therefore, access to care. It permits a streamlined application process, and what it does is, it's like, for those of you who have college-age or high school-age kids, it's like the uniform college application. You fill out one application and put together one set of supporting materials, and then it goes out to the compact states, and you can be licensed in all of them. Obviously, it's not limited to telehealth. but its benefits to telehealth are substantial and I would say obvious. There's only 12 states that have the compact now. They're listed on the slide. Another 13 have introduced legislation to adopt the compact. So assuming that it passes in all 13, half the states will at least be compact states and will be, have a streamlined licensure process. Parity is another legal concept that people generally think of when they think of telehealth, and that is, do insurance companies have to pay for telehealth services like in-person services? Parity is increasing quickly, but not all parity is equal. There's a distinction between a requirement to pay for telehealth services and a requirement to pay the same amount for a telehealth encounter. And so even people that go into a state that is supposed to have parity need to pay attention to what that parity actually means. As I said, a majority of states have parity laws, but the coverage varies. Here's a map. The blue, which is, as you see, more than half the states have telehealth parity laws. Arizona, for some reason, has a partial parity law. And the other states are still getting there. And that obviously, it doesn't mean, by the way, that you can't practice telemedicine there necessarily. What it means is you might not get paid for it, which to many of you is kind of a drawback. Okay, Medicare currently, and any of you that are telehealth providers know this, but I'll go through it quickly. Medicare does currently cover a limited set of telehealth services, but as with anything else that involves Medicare, it's got statutory or regulatory conditions of coverage that are restrictive. It requires qualifying originating sites for the patient to be in, or a rural location, or other requirements. So in 2014, which maybe wasn't last year, but was pretty recent, Medicare only paid $14 million for telehealth services, which, when you consider what Medicare pays, is ridiculously low. Okay. Last month, legislation was introduced to improve Medicare's adoption of telehealth. It's called the CONNECT Act. I didn't include what CONNECT stands for, and I frankly don't remember. But it permits additional originating sites, permits further telehealth and remote patient monitoring in community health centers and rural health clinics. And it allows telehealth and remote monitoring to be basic benefits in Medicare Advantage, which is an improvement. So the sponsors of this legislation estimate that the act will save $1.8 billion over 10 years, which again, considering the total amount that Medicare spends, is not that much money. I mean, it sounds like a big number, but for Medicare for 10 years, not that much money. So in my view, they need to do more. In Dr. Boxer's view, they probably will, but we're not there yet. Okay. We also, in addition to licensure and parity, have other telehealth-specific laws. For example, location requirements. What is a qualifying originating site? And some states, I'm going to say prescribe, but that would be an unfortunate use of words. Some states lay down rules for how you have to establish a physician-patient relationship in order to have a legal and reimbursable telehealth encounter. So first of all, location requirements. Tennessee defines telehealth for purposes of its parity law. Again, this is what makes insurance companies pay for a telehealth encounter, defines telehealth to require that both the provider and the patient be at a qualified site. So it's a doctor's office, a hospital, a clinic, a rural health clinic, a FQHC, a licensed facility, or any other location deemed acceptable by the health insurance entity. So again, this is a definition that relates to what an insurance company has to pay for. And in order for the insurance company to have to pay for it in Tennessee, the originating site is specified as a clinic or a hospital or a specified place. Not the patient's home, not remote patient monitoring. None of that is going to be covered in Tennessee unless the carriers want to. And some of you may have experience with carriers that don't always just step up and volunteer to pay for things. Okay. Establishing a physician-patient relationship is another one of these. Dr. Boxer alluded to this also. The Texas Medical Board has a rule that before a physician can prescribe via telehealth, they have to establish a doctor-patient relationship, which at the beginning has to include an in-person examination. So questions and answers exchanged by email, text, or telephonic evaluation are not sufficient to establish a doctor-patient relationship that would permit a doctor to prescribe via telehealth. North Carolina has decided that this is a standard of care issue and leaves it up to the provider to determine what they need to do to establish the doctor-patient relationship. A licensee's evaluation of a patient does not have to be in person if the licensee employs technology sufficient to accurately diagnose and treat the patient in conformity with the applicable standard of care. California, another more enlightened state, requires an appropriate screening examination, but also leaves it up to the provider to determine what they need in order to appropriately screen the patient. West Virginia approaches it a little differently. They set out in their statute what technology you have to have in order to have a viable or effective doctor-patient encounter via telehealth. So they say a physician-patient relationship may only be established through the use of telemedicine technologies, which incorporate real-time video conferencing or similar secure video services during the initial physician-patient encounter. Email, no. Telephone, no. They require video, but if you have video, they're okay with it. Okay. Other healthcare laws that are not telemedicine specific may also apply in certain states. And this is where, even in my experience, sophisticated telehealth providers sometimes get tripped up because they are completely on top of licensing, on parity, on what it takes to get reimbursed by an insurance company in a particular state. They know how to establish a doctor-patient relationship, but if they start out in a state, for example, that's not a corporate practice of medicine state and set up their business as a general business corporation and try to export it to a corporate practice state, they can have problems. Dr. Boxer also mentioned the prescribing and physician dispensing. Prescribing and physician dispensing are issues in telemedicine. They're different things, though. And you could get easily tripped up if you, via telemedicine, are shipping out medication to the patient rather than just writing a prescription. And finally, language interpretation requirements. You have to be sure, obviously, and this varies state by state also, what is required when you are permitting patients to access health care via telemedicine, what you have to do to be sure that they are understood and can understand what you're telling them. And that, of course, was the focus of yesterday's language track, but it's also a matter of individual state law. So, corporate practice of medicine. Many states, in the United States are what we call corporate practice states. And that means that they, prohibit general business corporations or LLCs that are not professional entities from providing medical services, which means, for example, in California, that doctors cannot be employed by hospitals. They cannot be employed by general business corporations. If Rite Aid, for example, wants to establish a convenience clinic in California, it cannot hire a doctor, put him in the office, and have him provide medical services to the public. Instead, medical services can only be provided by professional corporations in California and a lot of other corporate practice states, including Texas, including Nevada, including New York, including Pennsylvania. And obviously, this will affect how you would structure your telehealth business because different states require different types of business organization. So you can be set up legally in Colorado and run into problems if you are trying to export your model to California or Texas or Illinois or some other state. So as I said, California Professional Corporation can only be owned by California licensees. And if it's a medical corporation, at least a majority of the shares have to be owned by licensed physicians. A minority of the shares can be owned by other licensees, nurses, chiropractors, dentists. And California is not a compact state. So again, you're looking at providing medical services to patients in California, who can do it, and how difficult is it going to be to get their license. New York permits the qualification of foreign professional corporations. So you could have your California professional corporation provide services in New York if all of the shareholders of your California professional corporation also have a New York license. Again, New York, not a compact state. So of course, you can get them licensed in New York, but New York is not going to make it quick or easy. Pennsylvania, another corporate practice state, but Pennsylvania permits physicians licensed in other jurisdictions to own shares in a Pennsylvania professional corporation. So they're a little easier to work with. And they might have the compact soon. So it might be pretty easy, excuse me, to get a Pennsylvania license for a doctor licensed in another compact state coming up. So how do you structure a telehealth business providing medical services in California, New York, and Pennsylvania? The California Professional Corporation works for California. It'll work for New York also if the doctors are licensed or get licensed in New York. The licensed California and New York physicians can own a Pennsylvania PC, and then your telehealth business can operate in those 3 states, but we don't have enough information to know whether it can operate in any other states, or we don't have it right here. The other option, if you're going to be multi-state early on, is to consider an MSO, a management services organization, which is how businesses in corporate practice states tend to permit lay ownership and control of the business. And what that is you form a management company. That management company contracts with a legal provider in that state. In California, it's the California Medical Corporation. In Texas, it's the Texas Professional Medical Corporation, or LLC. And the MSO provides all of the non-professional aspects of the business. So in your telehealth business, the MSO would provide, in addition to billing and accounting and human resources and all of those services, it would also provide your telehealth infrastructure and would, through that structure, essentially own the business, even though in each of the corporate practice states, the medical practice is actually owned and operated by what lawyers call a friendly PC, which hopefully is friendly and stays friendly, because it is the vehicle through which the lay telehealth company can actually practice medicine in a corporate practice state. Okay, Dr. Boxer talked about this. I am not convinced that the primary reason that we have telehealth is to get prescriptions, but Dr. Boxer has spent more time in the industry than I have, so he may be right about that. Prescribing generally follows the same rules as licensure. If you can practice medicine in a state, you can generally prescribe in that state. But remember Texas, of course, has special rules. So you cannot prescribe, a Texas telemedicine encounter cannot result in a prescription unless there has been an initial in-person encounter first. So in Texas, I guess, nobody is prescribing Viagra over the internet or whatever it is. If the telehealth provider dispenses medication to patients in remote locations, laws relating to physician dispensing will be implicated. So that's, again, slightly different issue. Physician dispensing is in-person medicine, and you all know what this is. You go to the doctor's office, the doctor says, you need a Z-Pak, and he gives you a Z-Pak. He dispenses it right there. Different states regulate physician dispensing differently. The New York Board of Pharmacy says that physicians may never dispense in New York. In New York, a physician writes you a prescription, you take it to the pharmacy, that's it. So if your telehealth business involves sending out medication to patients who are located all over the place, you can expect issues if the New York Board of Pharmacy finds you physician dispensing to a patient in New York. In California, physicians may dispense as long as they comply with all the statutory requirements regarding labeling. In Florida, you have to register. So on physician dispensing, you can already see that if your telehealth business model involves shipping medication to patients, you are going to need to establish a very close and possibly expensive relationship with a lawyer, because states are all over this and they are very serious about shipping drugs into their state, even if it's drugs that healthcare providers consider relatively innocuous. If they're prescription drugs, states are sensitive about it. Okay. And at last, the other set of laws that could trip you up if you're engaged in multi-state practice, especially technology-enabled multi-state practice, are language interpretation requirements. So here we do actually have a couple of federal laws. First, the ADA, Americans with Disabilities Act, requires public accommodations, which is every doctor's office and every hospital and every clinic in America, to ensure that no individual with a disability, including deaf or hard of hearing, is excluded, denied services, segregated, or otherwise treated differently than other individuals because of the absence of auxiliary aids and services. So many people think that that is a statutory requirement for live ASL interpreters. That's not the case, but you do have to do something. So if you are a public accommodation, which if you're a hospital or a clinic, you are, you have to be able to communicate with deaf and hard of hearing patients. You are allowed to use less expensive modalities of communication if they are effective. So you can write notes back and forth if that works. You can communicate via typing text answers and questions back and forth on a computer, if that works. But you do have to be able to make your service accessible to them. The Civil Rights Act of 1964 deals with limited English proficiency individuals because LEP individuals are considered to be within the group of people protected by laws against discrimination on the basis of national origin. So, if on the one hand you have the ADA, which deals with deaf and hard of hearing, and on the other hand you have the Civil Rights Act. The Civil Rights Act, in theory, applies to a smaller universe of providers, but not really, because it applies to any entity receiving federal financial assistance, which includes Medicare Part A. So hospitals are right in there, which, I mean, you all know that. That's why you're all here at a land conference. So hospitals must take reasonable steps to ensure meaningful access to their services by LEP individuals. Okay, so we got that. That's federal law. It applies to everyone. But states also have laws. So Mississippi requires telemedicine equipment and the network used for remote patient monitoring services to accommodate non-English language options. Okay. Do they say what those are? No, they do not. New Mexico requires managed care organizations to ensure that telemedicine services meet cultural and language needs. Do they say how you do it? No, they do not. New York requires, and I'm going to apologize for New York right here. I know this should be interpretation and not translation, but New York says in their statute, culturally competent translation services for telepsychiatry. So, boo, New York. Anyway, that was a very quick overview of what you need to watch out for when you embark on a multi-state technology-enabled medical practice, because again, we have a patchwork of laws. Licensing laws are only the starting point. You need to be aware that a business model that is perfectly legal and makes perfect sense in the state where you set it up may not be exportable certainly without legal review, and you may need to do more than review. You may need to actually change some things. And remarkably, right on time.